David Bruno. David, thank you so much for being with me.
Pleasure. Thanks for having me, Mike.
All right, let's go through just a couple of those things. I mean, we can kind of skip over the housekeeping regarding the exhibit. That's fine. I think that's pretty clear. The milestone camera issue that came up there, the defense is concerned that the jury might not get the best look at that video. Again, this is a sort of video from across the street. There was a police camera that was viewing the incident. It was essentially the view that the 911 dispatcher had when she decided to call in help because of what she could see. And there was some technical issues. And also the player itself, I guess, allows you to zoom in and zoom out, which I guess when you're playing it on a computer, you can't do. I see it as a legitimate concern by the defense, but I think the judge made the right decision because the prosecution did not use that player when playing it in court.
Yeah, no, I agree. I mean, first, the reason I think they want that in is because they want this jury to look at this for the totality of the circumstances and not just those zoomed in videos that we've seen over and over and over again. You heard that from the expert today, totality of the circumstances, taking a step back. And literally what that camera does is take a complete step back and look at it as a whole. But you're right with respect to the technology issue, and I have the same issue in my jurisdiction, where we don't want jurors taking equipment like that and giving any extra attention to one particular thing that wasn't presented in the court in that way. For example, when we have defendant statements, we don't like them to have the ability to look at one particular portion of the defendant's statement over and over again. We will bring them into the court to do readbacks instead of sending technology in. So that's where I think why the defense wanted it in, and that's why I think the court prohibited the technology from going in the room.
Yeah, that's an excellent point. That's wonderful for our viewers to understand. The idea is that if you give it this kind of attention, you send this special player back, it almost flags it as something they should be paying more attention to. And that's not to say they shouldn't be paying attention to it, but you don't want to flag it as something that might need more attention.
Agreed.
All right, let's move on to that next issue, the issue of disclosures. We've all been there, right? You get you get these boxes, and there's probably 50,000 pages worth of disclosures and different things that the prosecution might intend to use. Some of it is gamesmanship, but at the end of the day, to expect the defense to go through those and be ready for any kind of impeachment that might happen, I think is asking a lot. And I think the judge was correct in trying to get them to at least give them some direction as to where they might go. But by the same token, I don't know how useful that's going to end up being.
I'll tell you what. Well, first of all, Eric Nelson has to go back to his office or wherever that is, and he has to prepare for the most important day in this trial. I mean, he really got smacked around today with this use of force expert. I mean, we'll go into it a little bit more. What I would expect the other experts to be testifying about is the causation issue. And that is it. That is where the defense has to hit home if they're going to get any good verdict here, because it's not going to be on the use of force point. Causation is a real issue. I mean, with the fentanyl and the meth and the heart issues and the discrepancies between the state's expert and Dr. Baker, I envision that the experts coming up tomorrow are going to be on the causation with medical testimony. So now Eric Nelson has to go back and worry about these 50,000 pages that he just got that his experts could be impeached with. And the judge's ruling really didn't do the defense attorney any service here, because essentially the court said, yeah, just tell them what you're going to use. And do you think they're going to go through all of that and give them everything? So that's a big issue, and Eric Nelson has to be worried right now about 50,000 pages that were lumped on his desk that could be used to impeach his most important witnesses tomorrow.
Yeah, so, I mean, I just want our viewers to understand this. I wouldn't call it uncommon, but it's almost like there's a certain level of respect that you give each other in this way. They knew who these experts were going to be. It's a little surprising that he's getting it on the eve of their testimony.
Yeah, no, absolutely. I mean, there are discovery rules that prevent this from happening. And then also what the court suggested is the possibility of a continuance, which is a delay, which would give the defense attorney enough time to review the impeachment material before the cross-examination, which nobody wants to do in the courtroom, considering that we were told that there's potentially closing arguments on Monday of next week.
Yeah, and this could definitely, if there was a continuance, absolutely put that in jeopardy. And I would say, I would even go so far as to say, had this not been the high-profile case that it is, I think you definitely would have seen a continuance under these circumstances, if only just to slap the prosecution for being, again, I don't want to use the word disrespectful. What word would you use here by dumping them with these documents the day before?
It's gamesmanship. And that's what it was.
Fair.
I mean, we're talking about probably transcripts that the witnesses probably testified to. We're talking about reports that maybe they dug out. I mean, that's what you do when you try to impeach experts. You want to try to get everything that they've written, that they've said, that they've recorded, that they've transcribed. I mean, bring out the friends for prior statements that may be inconsistent with testimony. I mean, we know right now for Dr. Baker, there are some written notes out there as to what he said in a private meeting with prosecutors that Mr. Nelson intends to get into. I don't know how he's going to present it, but we're aware of those notations about the individual with the fentanyl being left in a room with no other causes.
Yeah, it could get a little bit messy, that's for sure. But at the end of the day, they're going to move forward. Judge Cahill has put this trial on a train, and he's not letting that train stop for anything. I want to bring in my guest, again, criminal defense attorney and former prosecutor David Bruno. And before the break, you mentioned that it was a bad day, didn't go well. I'd have to agree with you. He said some things that defied logic as far as I'm concerned. But let me get your opinion on how that use of force expert Barry Broad went over.
Yeah, just on that point alone, when he talks about one-upping, he was impeached on it because that is not what the police department's use of force policy says. They say it's got to be proportionate, not one-up. And that's not also the legal standard that this jury is going to be assessing this case. That's going to be the reasonable police officer. So that, and I agree with most of what he said, but as it's applied to the George Floyd situation, there is a point where he is in the prone position where he is no longer a threat. In fact, the expert pulmonologist that testified in the state's case point to when he died, literally, and he was not moving for minutes, and the defendant stayed on top of him. So that's where he loses credibility. And in fact, I think the defendant and the defense attorney lost credibility today as well, because when you look at that video and you look at the common sense of it, for example, they're trying to explain why George Floyd wasn't picked up, put in a safe position, or brought over to the sidewalk because of various different reasons. I mean, he's in the middle of the street, and there's 4 police officers there, including a parked police officer across the street. I mean, there is no reason why George Floyd had to remain in that position for that long, especially after he went unresponsive. So that's the common sense that this jury is going to be using when assessing the credibility of the defense witness today. And the witness testified about the other issue, right? That's the reasonable officer issue. That's whether or not it's culpable negligence. And again, I think this is a real causation issue. They would have been better off really saving face and not going in the direction they did today and really zero in on the causation issue, because they may have lost some credibility in the jury's mind today.
You know, David, we've been saying that all along. It started early on when Eric Nelson started to go after this idea that it was this crowd that was forming, that was sort of informing Derek Chauvin's opinions to not help George Floyd. And he went, he went along with that same argument today, suggesting that, again, it was reasonable because he's looking around at the totality of the circumstances. And we were saying even then, he needed to shift gears because it is not supported by the video, and there becomes a credibility issue. And I think that, again, happened today, as you're mentioning, with this expert. He even said something that I had to write down. He said that positional asphyxia was only a danger for the morbidly obese. And he was questioned about that and impeached on that on cross as well. But I mean, I can't believe that based on what we saw from the prosecution, that this guy is going to win the day over what we heard there.
Yeah, can I speak to that, Michael, if you don't mind? I mean, one of the issues, he said that it's not a use of force to put the George Floyd in the prone position. And it wasn't a use of force to put the knee on top of George Floyd. And there was a back and forth in cross-examination where that was considered on George Floyd or not. I mean, you got to be kidding me, because Exhibit 17, it was used today in cross-examination, and I would have used it too. There's a frame where the defendant's foot is actually off the ground because he's putting so much pressure on George Floyd's body.
Yes.
So to take the position that George Floyd was not put in a use of force position by being put in the prone position, and then also when the knee goes on top, that's not use of force,
David,
is another area where he's just crushed.
I agree with you 100%. Sorry I had to cut you off because we do going to have to go to a break. This is one of those hard breaks, I'm being told. So I want to thank you so much. I wish we had more time to talk, but hopefully you'll come back and join me again. We'll take you to